Good afternoon. My name's Howard Black. I'm the Director of Communications for the 4th Judicial District Attorney's Office. Today we want to spend a little time with you, reference the preliminary hearing, which finished earlier today. District Attorney Michael Allen, that's M-I-C-H-A-E-L-A-L-L-E-N, will be giving an overview. And I would always caution that we're going to stay focused on that information that has already been presented on court, that's on the court record. Obviously, we still have an active trial ahead of us. And one other comment I would like to make, please be respectful of our victims. We have many victims who are not wanting to have any conversation with the media, and obviously we have some folks who are willing to speak to you all. But I'd just like us to be somewhat careful. We spent some time, some really quality time with our victims today after the preliminary hearing, and that's some of the information that was shared back to us. So again, I know most of you are very, very respectful, and if we can continue to stay in that vein, I would appreciate it. We will take some limited questions at the end of Michael's remarks. With that, I'd like to introduce Michael Allen, the District Attorney.
Good afternoon, everybody. Yesterday, members of our prosecution team, standing to my right, and I presented evidence in court towards establishing our burden of probable cause at a preliminary hearing on the Club Q shooting. This morning, Judge McHenry found probable cause to support all charges in this case and bound the defendant over for trial. The court also considered the defendant's bond conditions and made a legal determination that the proof is evident and the presumption is great that the defendant could be convicted at trial. The result of that finding is that the defendant will continue to be held without bond, meaning he will stay in custody while this case is pending. I want to reiterate what I've said in the past. We will not be trying this case in the media. I want to make sure that what we talk about today is only things that have been released publicly in that courtroom, and even some of those things to protect the fairness of this trial process may not get into. I want to also reiterate that the defendant, this defendant, like all criminal defendants, is presumed innocent of the charges that we filed in this case unless and until those charges are proven beyond a reasonable doubt in a court setting. The findings made by the court today by no means change that obligation at all. The next setting for this case includes a status conference on March 31st, 2023 at 3 p.m., and then the defendant will be arraigned on May 30th, 2023 at 3 p.m. At that arraignment, we expect the defendant to formally enter a plea. As is typical in most homicide cases, we anticipate that plea to be a not guilty plea. That is fairly standard practice. I do want to take this opportunity to thank the many people, victims, family members, and victims themselves who have been impacted by this case for their patience as this case works through the judicial process. The hurt they feel is very real, and there's no way to get around that. And that's why Howard asked for respect and dignity being given to those victims and their family members. It's something that as a community we should all be focused on. I also want to say personal thanks to the Colorado Springs Police Department, the FBI, the ATF, and the members of our team here who have assisted in the efforts towards this step in the process. And then finally, I want to just point out and specifically thank Detective Rebecca Joins with CSPD, who is the lead detective in this case. Her service to the Colorado Springs community is nothing short of amazing, and her performance in this particular case is evidence of that. With that, I would ask if there are any questions. Yeah, Colette.
Is there any plea deal being discussed, or do you think that we will be getting to a trial?
So the way that we look at these types of cases, that we proceed as if we're going to be going to trial, and that's how we're proceeding on this case, preparing for trial. Yes.
Do you anticipate a plea of not guilty by reason of insanity coming in? And if so, how would that affect the timeline of the trial?
So that's one of the things that the court addressed with defense today, whether they would be pursuing a not guilty by reason of insanity plea. It's too early to determine whether that will happen or not. The defense, as was instructed by Judge McHenry this morning, will be looking into those issues and will be prepared to address the court on that particular issue on that May 30th date.
Thank you.
Yes.
Can you talk a little bit about this website that we heard about in testimony that the suspect had been running with concerning content on it?
So the only thing that I will say about it is what I said in court and what we heard as far as testimony, that it was a website that the defendant was an administrator to, that there was a video that had been posted to that website that was characterized as a neo-Nazi propaganda video that included scenes of shootings in Europe, and that would be the extent of it at this point. Obviously, that was evidence towards the bias-motivated crimes that we charged in this case.
Was that a website that like everyone had access to if they were to find it, or was it on the so-called dark web per se? How was it accessed?
So that was not anything that we put into evidence at the preliminary hearing, so I'm not going to answer that right now. Yes.
Based on your experience, do you think you have a strong case for the bias motivation charges?
I do, and the reason why I say that, and I want to clarify too, when I say that I feel like we have a strong case, again, have to take into consideration that this defendant, like all defendants, are presumed innocent until proven guilty beyond reasonable doubt. The statute for bias-motivated crimes in Colorado was amended just 2 years ago. It used to be that we had to prove that somebody acted specifically for those reasons, but the wording was changed that we only have to prove that somebody acted either wholly or in part by their bias towards a particular group. That change in the statute allowed us to charge a lot of these offenses in this particular case.
The defense was saying he didn't find a manifesto, there was nothing to encourage other shooters as evidence of not being bias motivated. Can you respond to that?
I would just respond to that with the idea that there's no single case that's just like any other case. So the same pieces of evidence that may be found in one particular case in some other part of the country may not be present in a case that occurs in some other part of the country, and would leave it at that.
The defense says their client uses they, them pronouns, but in the examination, the DA's office has consistently said he, him. Is that a conscious decision?
Actually, no. I try to refer to that person as the defendant. If there have been any slips on that, that's unintentional. Obviously, there's a lot of testimony. You probably, if you paid attention to the preliminary hearing, even some of the witnesses would sometimes revert back to that. It also makes it hard, actually, for the court reporter when they might say they, and not being clear who that they person is. And so, for my purposes, I like to say the defendant because it just makes it very clear who I'm speaking about. But any other slips of that is unintentional entirely.
When you guys say that video, the wrong target video mentioned was posted on that website, do you believe that it was Aldrich who posted the video to that website, just to be clear?
The evidence that we presented at the preliminary hearing is that it was posted to that particular website, of which the defendant, through testimony, was the administrator of that website. And then beyond that, to get to the actual heart of your question, that was not evidence that we presented at that preliminary hearing, so I'm going to refrain from going as far as what you're asking.
Okay.
Can you give us a sense of the comments that were made by Laura V. on the WebEx and whether you think that's going to impact the case going forward?
Yeah, I'm not going to make any comments on that. Yes.
Do you anticipate this trial being held in 2023, or is it going to be further out than that?
It's really hard to say. Obviously, we've just come out of a period of time where we had outside forces that really impacted our ability to get cases to trial, and I'm talking about the COVID pandemic. Hopefully, we can get to a trial process this year, but there's a pretty decent chance that it could be next year even. And that's just speaking through relative terms as it relates to a lifespan of a case in the court system. If we have other outside forces like a COVID pandemic that rears its head again or something like that, that could obviously have a negative impact on our ability as well.
Is a federal case being pursued, and does that carry the death penalty?
So the federal system does still have the death penalty. Any questions about that, I would be best advised to tell you to reach out to the federal authorities.
And are they pursuing the case?
Again, reach out to them. Yeah. Yes.
Some bit of talk today about that video, the surveillance video inside of Club Q and whether or not it should be shared. And I'm curious if your position is similar to what was shared today, that it would do more harm than good for it to be publicly released.
Yeah, so here, the thoughts that I have on releasing that type of evidence in this particular case at this time are twofold. One, we have in our Colorado Constitution the Victims' Rights Act, where we have to treat victims, and it's the right thing to do, whether it's in the Constitution or not. But that is to treat victims with dignity and respect. If a video like this, and it's a graphic video, we purposely submitted it just to the judge to view as opposed to playing it in open court, would potentially not be treating victims with dignity and respect that they deserve. So there's that part of it. The other part of that is the constitutional right that we all have, and that is constitutional right to a fair trial. We all have that right. This defendant has that right as well. And so if we release specific types of evidence that are particularly graphic in nature, that could impact the defendant's right to have a fair trial process. So we're trying to protect both the victim's interests and the defendant's right to a fair trial.
Have the families asked you to not have that played or released publicly?
There have been concerns expressed to us about that being put out in the public, yes. Any other questions?
I have one
Yes.
question. Who entered into evidence all the pictures of the pills that the defendant was allegedly in possession of or taking? Was that you?
Those were defense exhibits. Obviously, those pictures come from the investigation, but they were defense exhibits.
Do you believe that might be part of a strategy to prove that the defendant may have mental incompetencies or a sanity issue?
If you paid attention to the, and I'm not saying you didn't, but if you listened to the words of the defense, it's likely that that's what that would be used for. Yes.
Just to clarify, I know the list of charges was over 300. What is the exact number of charges?
I don't have the exact number of charges on with me right now. It's 323 or somewhere in that neighborhood. Obviously, the vast majority of those charges are victim-centered charges. So for each particular victim, they're grouped by charges for that particular victim. And then beyond that, there are crimes of violence charges that we also add on to a case like this. And what those crime of violence charges do just require a sentence in prison. And that's really what the significance of those charges is. The exact number, any of you have, is it 323 or?
I'll tweet it out.
Yeah, we can tweet it out. It's a big number. It's the biggest number of charges I've ever filed in a particular case.
Just a logistics question, sorry. There was talk that this preliminary hearing might take 3 days. It ended much sooner. Did something move much faster than you thought, or was there a change in the plan?
So when a case is being scheduled for a preliminary hearing, typically what you would look at in determining how long it will take is just the breadth of the investigation. Obviously, this case, as evidenced by defense statements in court in previous occasions, has indicated there's a lot of reports in this case, meaning that a lot of different people were involved in the investigation process. And so it's at that early stage, not knowing necessarily what evidence we want to put in. And then obviously you saw that it went a lot faster than any of us anticipated, and that can happen sometimes. Yes?
I just want to clarify your thoughts about the suspect's sexual identity. Do you believe he's non-binary?
My belief has nothing to do with that, so I'm going to refrain from.
Based on the testimony from the detective, do you believe he's non-binary?
Again, you can jump to your own conclusions as far as that goes. Whether I believe he's non-binary or not doesn't really have any impact on how we're prosecuting this case.
Could you at least then clarify what the detective testified to as far as that goes?
So basically that there was testimony that people had said that the defendant's mother identified as non-binary and that the defendant had never identified as non-binary prior to that. And that's really the extent of it. The non-binary issue as it relates to the defendant himself never came up, at least publicly, until we got into the court process.
And do you think that'll be an important part of the case?
No, I don't think so. Yeah.
I know it was said that some quality time was spent this morning with members of your office and the victims and their families. Was there any resounding thought or message that seemed to be present in a lot of those conversations that you think is important to share on behalf of the victims?
Those are private moments that we're not going to share publicly. Those communications are better between us and the victims directly as opposed to putting it out for everybody to know about.
There's no overwhelming message that they would want the public to know about this process?
Well, I can tell you that just based on the sheer number of people that were present for both days, yesterday and today, indicates a very strong solidarity with what we're doing here in the prosecution effort. The fact that they were so interested in being in court, at least a great number of them, and then sticking around and meeting with us after the fact goes towards that solidarity. And I think that's the message that we would push out as far as it goes to that. But what they specifically said or what we might have said to them, I don't want to get into. Yeah.
Is there any evidence that
that's one of those things I'm not going to get into right now. Yes, ma'am.
Does your evidence support that there is a case to be made that Anderson is insane? And what sorts of things do you look for to undermine that plea?
So I will say, first of all, to the first part of your question, I'm not going to jump to any conclusions based on what we know at this particular stage. It would be improper for me to do that. Secondarily, I'm just going to speak as to a general sense when we've had these instances come up in other cases. Typically, if a defendant is raising those types of issues, they'll be evaluated by a psychologist. There will be some neurological testing that's done. Typically, that will lead to a report that's generated. That will then lead to the opposing party, the person that's not alleging that this is happening, to seek a second opinion. So in a situation like this, if a defense expert says somebody is insane at the time of the offense, then we will have the state hospital look at that person as well, and even potentially engage with other doctors as well. So that's generally how that process works.
Well, what about some of these elements of planning the night of the crime, like leaving the car running, leaving the door open? Just some indications that there was some logical thought process
So,
going on.
yeah, so good question. I'm going to answer that again in a very general sense. All things that a person does in the commission of the offenses that they are charged with can be factors that go towards those very issues that you're asking about.
And what about this idea of intoxication? How does that play into the insanity plea?
So generally speaking, intoxication can be used to take away specific intent. So if somebody has intent and deliberation charges pending against them, but they were so drunk that they couldn't form a specific intent, that can take that away. And I'm, again, speaking in a very general sense.
Do you have any more evidence of bias that you didn't present during this hearing that might be coming up?
We would only talk about things that we presented in the courtroom yesterday with evidence. Yes, Colette?
I just wanted to distinguish, when you're talking about more than 300, is it charges or counts?
Same thing, charges, counts, yeah.
Okay.
Used interchangeably, yep.
Thank you.
Mhm. Anything else? Yes, sir.
Was wearing a mask today in the courtroom. Were you told why, or do you need to be told why? Didn't have one on yesterday and had one today. Do you know the reason for that?
Honestly, I didn't even notice that he was wearing a mask today. And no, we don't get told that information necessarily unless there's some sort of a health threat or something like that.
Yesterday, the defendant seemed to be fidgeting quite a bit in his chair and at one point was crying, leading to recess. Does that have any bearing on the proceeding in any way?
No, it doesn't. In fact, generally speaking, as we're presenting evidence in a setting like that, whether it's in a preliminary hearing or trial, we're focused on what's happening on the witness stand, not what's happening peripherally to where we may be sitting. All right. Well, thank you all so much for being here. We appreciate helping us get the word out about this particular case. It's obviously drawn a lot of attention from the media and the public. There's always a tension that exists in cases like this in which the public and the media want more information than what we can realistically give. But understand the reason why we don't give that information is because we're trying to protect this process, making sure that when and if we get to a conviction, that it will be a sound conviction that will be upheld by any appellate review. So thank you again.